Hey guys, this is John Watson. I want to cover a Fair Debt Collection Practices Act case. Although it's not going to really be that involved in the FDCPA, instead it's going to be this issue of standing that we've talked about before. Do you have the right to open the doors to the courthouse? But really the reason I want you to see this case, and this is the Madison Avenue Associates case from the 7th Circuit Court of Appeals, decided June of 2019. The real reason I want you to see this is because sometimes when I'm talking with people or somebody will write a comment and they'll say, this is absolutely the way it is. And they tell me some principle of the law. And I, realize this person doesn't have any training, has barely done any research, but yet they are absolutely confident. What's that old expression? Often wrong, never in doubt. There are very few things in the law that are just absolutely 100%. There are a few things, but not many. And I want you to look at this case because what the 7th Circuit Court of Appeals says is for a particular violation of the FDCPA, you absolutely do not have the right to come into court. The identical case in the 6th Circuit Court of Appeals, they say you absolutely do have the right to bring a court action. So here we have these two circuits, and the circuit courts are over various states. So for example, I'm in the 11th Circuit, which is Alabama, Georgia, Florida. But you have these two circuits that are totally opposite on this. And even within the 7th Circuit, you've got a number of judges saying, wait a minute, we're missing it here with this opinion. We're doing this the wrong way. So when somebody tells you, oh, I can guarantee you that X, Y, and Z, I would just be very cautious about that. They may be right, but there are a few things that are just guaranteed in the law. And so I think as you see this opinion, that'll become very clear to you. And I'm sure if you do much research, you'll run across other examples where different judges, sometimes in the same courthouse, interpret things differently. I'll give you one example. In the Northern District of Alabama, just think basically Birmingham North, there was an issue about, does the Fair Credit Reporting Act preempt or get rid of state law claims? So can I sue Equifax for defamation? Or is that tossed out because I had the Fair Credit Reporting Act? Well, within the one courthouse, we had judges that viewed it three different ways. So some judges took viewpoint number one, some viewpoint number two, some viewpoint number three. And so the point is that there's a lot of uncertainty in the law. And part of what we try and do in advising clients, whether we're representing consumers like I do, or the lawyers that are representing mortgage companies, debt collectors, things like that, is we're trying to say, look, I can't give you a guarantee on this is 100% the law, but I feel pretty confident about this, okay? And so we look at other decisions, and that's how we end up coming to an opinion about what something is or isn't under the law. So let's jump into this. So you can see from the very first sentence, kind of the tone of the case. Bottom line of our opinion can be succinctly stated, no harm, no foul. So the debt collector made a mistake, and the mistake is that we have this section 1692G, and we have a video on that, that talks about what you have to tell a consumer when you first notify or within 5 days of first notifying a consumer. So the debt collector did that, but neglected to specify you had to communicate in writing to trigger the statutory protection. So we've talked about this before. If you want to take advantage of that debt validation, that has to be done in writing. But this notice did not say that. So the consumer caught it and then filed a class action. And so the court says, well, look, all you're saying is you got an incomplete letter, and that's not enough to give you federal jurisdiction, or what we often call standing. So they say you cannot claim a bare procedural violation divorced from any concrete harm and satisfy the injury in fact requirement of Article 3. So Article 3 of the Constitution just establishes the federal judges. And the way they describe it here is federal courts have the power to address harms that defendants cause plaintiffs, not a free-willing power to hold defendants accountable for legal infractions. And we've also talked about in other videos, it's not to issue advisory opinions. Like you can't go to your local federal judge and say, well, if I do this, would that be legal or illegal? And they write an opinion. No, they have to stick with actual cases and controversies. So here's the gist of it. 1692 GA says written notice to consumer within 5 days of initial communication. There's 2 mechanisms debtor can use to verify debt. Can notify in writing, disputes all or part of the debt, and so the debt collector then has to obtain verification and mail a copy of that to the debtor. And if you don't dispute within 30 days, they can assume the debt's valid. And you can also make a written request to get the name and address of the original creditor. And the letter that we're talking about here failed to say that those things must be in writing. And there's been a lot of controversy over this. Sometimes debt collectors say, well, even though we said it doesn't have to be in writing, it does. But then others, I think pretty smartly for the debt collector, say, well, you still get all the protection. We didn't tell you it had to be in writing. We said you could do it verbally, and so we would have honored that. And courts have gone different ways on it. So here's a class action. And the opinion points out that the plaintiff did not try to dispute the debt, didn't even plan to dispute the debt. And so she sought damages, $1,000 statutory penalty for herself. And I'm a little unclear why it says $5,000 statutory penalty. Normally that would be $500,000. It's $500,000 or 1% of the net worth, whichever's less. I'm assuming that's a typo. It'd be a little odd to me if she brought a class action for $5,000. But anyway, so the parties eventually come to a settlement. But while that was going on, there was a case that was decided. And it's this Time Warner case, 7th Circuit, so same circuit that we're in now. And here the court describes it that plaintiff cannot satisfy the injury in fact element of standing simply by alleging defendant violated a disclosure provision. And so then the judge in that case had to dismiss the complaint. Let me back up. I think what they're saying here is the judge in this Madison Avenue case said, well, based on Groshek, now I've got to dismiss the lawsuit. And so then she appeals. So they're going to talk first about standing. So standing is an injury in fact that's traceable to the defendant's conduct and redressable by a favorable decision. So it's got to be some harm that's happened, and we'll define harm here a little bit later. And you have to be able to connect that with what the defendant did, and it has to be something that you can get some relief from that, usually in the form of monetary damages by a decision. And so this is rooted in Article 3, which limits federal courts' authority to resolution of cases or controversies. And if you don't have an injury that the defendant caused and the court can remedy, then there is no case, and so you get kicked out of court. As almost all of these do. It involves the injury in fact requirement. So we're not talking about was it traceable to the defendant or can you get redress for it? Because yes, you can get damages, and yeah, the defendant sent this defective notice. So it's really just this injury in fact. And so talk about it's got to be concrete, and particularized, actual or imminent, not just hypothetical. And it doesn't need to be tangible to be concrete, but must be real, not abstract. Here's the problem. What in the world do all these words mean? And that's a huge problem for all the courts right now. And so they say, all right, we're going to start with just because Congress has said you can sue doesn't mean you have standing. And let me put a little addition there, in federal court. And I won't talk about this very much because I think I bring it up in every video, but it's that important that My strong advice, well, I'll say this. I'm not going to give anybody advice. I'll tell you what we do. We bring these in state court because we don't have that standing issue. And they 99.9% of the time get removed or taken into federal court. We're fine in federal court. That's great. But if the law changes and suddenly your case is no good in federal court, well, then the judge should send it back to state court, what's called remand it back to state court. But here, it doesn't get remanded. It gets dismissed. The case is gone. And statute of limitation may be over at that point. So all sorts of problems. I think, at least for my firm, we do not file federal claims in federal court directly anymore because of this. And I want you to keep in mind, in this case, the Sixth Circuit has said you absolutely have standing for this exact violation. But now the Seventh Circuit is saying, nope, we totally disagree. And that's the risk that you run if you bring a case in federal court. All right. So going back to the Spokio, which is the Supreme Court opinion that kind of started all this, they say the role in identifying, elevating intangible harms doesn't mean you automatically satisfy this. Let me drop down here because some of this is repetitious with other cases we've looked at. And so let me do this part. The plaintiff cannot demonstrate standing simply by pointing to Madison's procedural violation. She must show the violation harmed or presented an appreciable risk of harm to the underlying concrete interest that Congress sought to protect. All right, well, what's the FDCPA to protect? Well, it's to protect you from the use of abusive, deceptive, or unfair debt collection practices by many debt collectors. So what does 1692G do? Well, it gives you a way to dispute or verify these supposed debts. So a debt collector reaches out to you, you're like, what is this debt? Go get me some proof of it. That's what 1692G is for. And it obligates, it says creditors, really they mean debt collectors, obligates debt collectors to tell debtors how to do that. And A4 and A5 reduce the risk that the consumer will inadvertently lose the protection given to those who actually follow the requirement. So, in other words, if you don't dispute it in writing, you lose some of your rights. And that's just the bottom line to it. So, the plaintiff did not allege the collector's actions harmed or posed any real risk of harm. She did not say that she tried to dispute or verify her debt. She didn't say she was even thinking about disputing it or contacting. And this is what they say. Now, I haven't read the complaint. I don't know if this is true, but the court says she complained only that her notice was missing some information that she did not suggest she would have ever used. And so I think this is a little bit of an overstatement, but this is what the court says. Any risk of harm was entirely counterfactual. She was not at risk of losing her statutory rights because there was no prospect she would have tried to exercise them. First of all, I think that's a little bit of faulty reasoning because we're talking about, well, what would you have done had you been given something that you weren't given? Well, it's a little hard to take yourself back in time and figure that out. But anyway, that's what the court does here. And so they say she had no more use for the notice than she would have had for directions accompanying a product she had no plans to assemble. Again, I think it's a little bit of an exaggeration, but you can see the direction the court's going. And she says, look, this is similar to this Robertson versus Allied Solutions case. And that involved the FCRA, Fair Credit Reporting Act. And so this is when an employer does a background check, or a potential employer does a background check. You have to give a copy of that background check before you revoke the offer of employment. And so they said, well, in that case, the Robertson case, she did satisfy the injury in fact, even though she did not allege, and allege just means in your complaint, what are your allegations, what are your factual statements, even though she had not alleged the report was inaccurate, or that she could have persuaded the defendant to hire her if she had received that copy of the background check or report. So the court's saying, you didn't get the report, but it was 100% accurate, and you could not have persuaded the employer to hire you had you been given a copy of it. And they said, even with all that, you can still move forward with that case. And so how does the court in this Madison Avenue get around that? Well, the plaintiff in Robertson, that Fair Credit Reporting Act case, alleged the defendant had not only violated the statute, but also harmed the concrete interests the statute protected. Well, what does it protect? So it requires the prospective employer to give the applicant a copy of the background report before it took an adverse action. Why? So that she would have an opportunity to review it and respond. If there were inaccuracies, she could identify them. If negative information was accurate, she could try to put the bad facts in a better light. Now remember, in that case, there's no allegation the information was wrong, or she could have persuaded the employer, but they still said she could bring suit. And so the plaintiff alleged the employer took that opportunity from her. By withholding her background report, it limited her ability to review the basis and impeded her opportunity to respond. And so the court says, looking back at Robertson, we emphasize that Article 3's requirements are met not only when a plaintiff complains of being deprived of some benefit, but also when a plaintiff complains she was deprived of a chance to obtain a benefit. And so, just to kind of summarize it here, she did not have to allege she would have retained or could have got the job offer she had access to report. Her lost opportunity to try to change the defendant's opinion, even though in that Robertson case, they're saying she could not have done that. But losing that opportunity was sufficiently concrete. Now, you would think the judges that wrote this Madison Avenue would say, hey, no harm, no foul. I mean, we didn't give you the background report, but it wouldn't have made any difference, so no harm, no foul. But they don't, and that's part of the problem with this whole standing stuff is there's a great lack of consistency among decisions, even within the same court. So here, going back to the plaintiff in this Madison Avenue case, says she does not allege any comparable loss opportunity, nor could she. And they say the FDCPA that was violated does not protect the consumer's interest in having an opportunity to review and respond to substantive information. They instead protect the consumer's interest in knowing her statutory rights. And I think that is true. I mean, the Section 1692 is advising you of your rights. Okay, so you could think of it almost similar to the Miranda warnings. Now, we have something in the FDCPA called the mini Miranda. That's where they have to say, this is an attempt to collect a debt. We're a debt collector. You know, the information we gain is to be used against you. So it's like the Miranda police warnings. And here in 1692G, it's saying, look, here are your rights. We have to tell you your rights. But Seventh Circuit's saying that is just not a big deal. And they point out in Robertson that they did, they made a similar argument there. All right. So the district court, that's the trial judge, said it's not like Robertson. Instead, it's a procedural injury under consumer protection statute, and that's it. And that's not enough. Okay. So let's highlight this section here. Going back to that Groshek case, defendant complied with the act by disclosing it would obtain, but violated the act's standalone requirement. We had a video on that maybe a month or two ago, that they had to give you a separate piece of paper, a disclosure on its own page. And they said, well, look, in that Groshek case, that was just a bare violation. And so let's get this part here. He hadn't claimed the improper format caused him to misunderstand the disclosure, hadn't asserted he would have withheld consent, hadn't said he was unaware, blah, 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 alleged a statutory violation completely removed. And they say that's not enough. And then they go to another case, the Myers case out of Seventh Circuit. So failure to truncate the expiration date from credit card receipt, this was not a problem. Now, the 11th Circuit has a case called, if I remember the name of it, Godiva Chocolate, I think, that's similar on this truncation that reaches the opposite decision. So again, there's a lot of uncertainty among the courts right now. So the plaintiff in the current case, the Madison Avenue case, did not allege she even read the disclosure, much less that she relied on it. Now, if she did read it, then she should have put that in the complaint, is what the Seventh Circuit's saying. Now, again, I disagree with that, because now they're starting to say, well, you got to put everything in the complaint. And then when you do that, they fuss at you and say, well, you put too much in the complaint. Your complaint's too long. But this is what the court's saying. And then they say, well, look, the Sixth Circuit case, and that's Macy case, the defendant violated the very same requirements that Madison did here. It failed to notify the plaintiffs they had to dispute their debts in writing to trigger the protections of the FDCPA. The plaintiffs there did not allege that they tried or had any intention to contact debt collector. Instead, they said that could lead the least sophisticated consumer to waive or otherwise not properly vindicate her rights under the Act. So least sophisticated consumer is what we view most of the FDCPA through. We don't necessarily look at you. You got the letter, you got the call. Did it trick you or confuse you? Instead, we say, well, let's imagine the least sophisticated consumer. Would it have tricked them or improperly influenced them or intimidated them, etc.? And the Sixth Circuit said that they had alleged a concrete injury. Remember, that's the opposite of what the Seventh Circuit's doing here. Because without the information about the in-writing requirement, plaintiffs were placed at a materially greater risk of falling victim to abusive debt collection practices. And they just say, we disagree. And it's certainly true the omission puts those consumers who sought to dispute the debt at risk of waiving statutory rights, but it created no risk for plaintiffs in that case who did not try and had no plans to try to dispute the debt. It's not enough the omission risked harming someone, it must have risked harm to the plaintiffs. And then they go, this is a 47-year-old case here, the Sierra Club from the U.S. Supreme Court. The injury in fact test requires more than injury to a cognizable interest. It requires the party seeking review be himself among the injured. And so they say, we're not going to follow it. And then the plaintiff also said, well, look at the Second Circuit in this Struble case. Plaintiff sued a bank because it provided and she signed a credit card agreement that allegedly omitted several disclosures required by Truth in Lending Act. And it failed to notify the plaintiff that a consumer dissatisfied with a credit card purchase must contact the creditor in writing. So the idea is you can't just call your credit card company and say, hey, I dispute that $57 charge at Target. You lose your rights if you do that. Have to do it in writing. And so the Second Circuit said you have a concrete interest in avoiding the uninformed use of credit and thus failing to notify the consumer of her obligations before she began exercising that credit create a serious risk she would unwittingly lose the very credit rights the law affords. And they said that's enough. And the Seventh Circuit says, well, there's some similarities. Both disclosures neglected to tell the consumer she must exercise her rights in writing. But then they say, well, look, in the Struble case, that, let me just get this highlighted, was supposed to come at the beginning of the relationship, and this would protect your rights that would occur in the future. Okay, and so it does put the plaintiff at risk because subsequent transactions might be invalid, and that triggers your obligation to object. And they say, we don't have any judgment about whether the Second Circuit was right or wrong. We just say, this is different. So, and this is a good point. When the plaintiff in Struble received the incomplete notice, she did not yet know whether she would ever object. But the plaintiff in the current case, it says she already knew she would not dispute the debt. And then there's a backup argument, and something that the plaintiff is calling an informational injury. And this is depriving somebody of injury is itself a concrete harm. And they say, look, you're not understanding the precedent, in other words, prior cases. So there are two major cases that address this informational injury. One is the Akins case, and then one is Public Citizen. These are U.S. Supreme Court cases, 98 and also 1989. And so in Aikens, we have political organization or voters sued to compel a political organization to disclose information that they felt the law required to be disclosed. And so the question is, well, do you have standing for this? And they said yes, because your inability to obtain information on the voter's view of the law statute requires that that information be made public. So that's enough. In Public Citizen, they wanted disclosure of consultations between the president and the ABA, American Bars, that's kind of the national organization of lawyers, regarding potential judicial nominees. So the Department of Justice refused to do that. Plaintiff sued, and the court said, well, you are seeking information and you were denied it, and that's enough, just like a Freedom of Information Act. In other words, they can't say in a Freedom of Information Act that, well, the information wouldn't have done you any good. No, if you can legitimately, or at least arguably, have a right to this information, you're denied it, that's enough for standing. So here we have the courts now going to explain why those decisions don't help the plaintiff. Those cases hold the denial of information subject to public disclosure is one of the intangible harms Congress has the power to make a legally recognizable harm. Okay? So public disclosure laws, sometimes called sunshine laws, protect the public's interest, and denying a request necessarily implicates that interest. The denial is directly related to voting, the most basic of political rights. And the plaintiff here doesn't allege that this is some sunshine law. Instead, she did not seek information at all. And admittedly, that's a clever argument by the court here. So a plaintiff who is not seeking to compel the defendant providing with information has not suffered the kind of concrete harm. And the FDCPA is an entirely different interest, and she suffered no material risk. And so they sort of get rid of that argument. And then she says, well, what about the Coleman case, the Havens Realty Coleman case? And she says, you suffer an informational injury, concrete injury, anytime defendant violates statutory disclosure requirement. So the plaintiff there was black, and they went to an apartment complex, and even though there were vacancies, according to the plaintiff, the apartment said, we have no vacancies. And they did that because the plaintiff was black. Now, the plaintiff had no interest in renting the apartment. All she was doing is just going there, pretending to want to rent. And then when she was told no, then she sued and said this was a racial reason and a misrepresentation, and that's enough to sue. And U.S. Supreme Court said, that's fine. Concrete injury under the Fair Housing Act, which conferred on all persons a legal right to truthful information. And so the plaintiff says, well, look, same thing as the FDCPA. And remember, in the Housing Act, that wasn't some public declaration. That was just between the apartment place and the plaintiff. And what the consumer in this case, the Madison Avenue case, is saying, well, look, I'm a consumer, and this is information from a debt collector to me. So it's enough for her to claim she was deprived of the information to which she was legally entitled, even if she wouldn't use it. Because remember, in the Havens Realty case, that person had no interest in renting a property. They were not going to rent the property. If they had been told, oh yeah, we have 27 vacancies, she said, well, I'm not interested, and then move on to the next place. But here, the court says this is different. So the bare harm of receiving inaccurate or incomplete information is not the harm the plaintiff in Havens Realty alleged. She claimed the harm of being lied to because of her race. And that was an invasion of the very interest the Fair Housing Act protects, freedom from racial discrimination. And they point out, and I'll tell you this, I don't really do anything with the Fair Housing Act, so I didn't know this, but this is interesting. Does not prohibit all misrepresentation, but only those made because of race or some other protected characteristic. And so because of that, that's why that lie was good enough to open the doors of the courthouse. And so they say, look, it's nothing more than a bare procedural violation that's insufficient. She asked for the opportunity to amend her complaint. And if this is true, this was, I think, a mistake. And this is something that I learned a long time ago. If you ask for the right to amend, I'm not talking about just maybe like one paragraph, but a whole, pretty major change to your lawsuit, the best practice, at least where I am, is you attach a copy of that so the court can look at it and say, well, if we did give you the right to amend your complaint, what would you have said? Here, they don't know. And so the court says the trial judge was right to deny you that. And then it says that she's forfeited a 1692F claim. And she's not challenged the dismissal, so she can't argue it now. And so it's a general principle. If there's something that you want to appeal, you have to say it. You can't wait till your final argument or wait till oral argument to bring it up. You've got to alert people. So they summarize the case. Caught the defendant in a mistake, but it's not one that hurt her. So here's something very unusual. And so normally these opinions are by 3 judges, and that's what this case is. And we saw one maybe a month ago where, in one of our videos, where there was a concurring opinion. But here we have the chief judge and then a couple more judges dissenting. Well, what are they dissenting from or disagreeing about? The denial of an en banc consideration. And that's the idea that instead of just 3 judges, you want the entire 7th Circuit, all the judges there to hear it. I don't know how many judges, I don't practice there. Maybe there's 30 judges. And so this comes up when a court, a panel, the panel's 3 judges, when they know they are directly going against sort of a sister circuit, okay? And so it's creating this conflict. Well, then they can ask the other judges, hey, do you think the whole court should consider this? The majority said no, but these judges are saying, yes, we should have considered it because we're going down the wrong path. And so here's what they say. From 10,000 feet above the ground, decision, lacks standing, seems sensible enough. Again, just to review, need injury in fact, which is one everybody fights over. Causal link, in other words, trace it to the defendant, and redressability. And they say, where you kind of come up short, Miss Plaintiff, is on that actual injury. But then they say, but look, the plot thickens when we look at the violation, the failure to warn her that a dispute over the debt or a request for information about the original creditor is ineffective unless it is made in writing. And they say, well, that's a bare procedural injury and that's not enough. And this has created a conflict with the Macy case in the Sixth Circuit. And so recognizing that it was opening up this rift, so depending on what part of the country you're on, totally different laws about this. The panel circulated its opinions to all the judges, and they have a local rule 40E. The question whether this was an important enough issue to warrant consideration by the whole panel, or the whole court, excuse me. And the majority said no, and the chief judge says, well, I disagree with that. The panel's opinion make it much more difficult for consumers to enforce the protections, and that alone is troublesome. But here's the whole reason this judge is writing this. What troubles me even more is the light this case shines on the need for a clear test in this circuit to distinguish between statutory protections that create, on the one hand, a, quote, bare procedural injury that does not support standing, and on the other hand, statutory protections for the type of concrete, particularized, actual, or imminent injury that meet Article 3 standards. And they say, look, this is not so obvious here that we should just, sort of skip it. Instead, saying we should have a full adversarial presentation before the entire court. So in other words, all the judges read the briefs, maybe there's oral argument, and all the judges get to decide this. And sorry about that, something just fell off my desk here. So it says, my concerns are both procedural and substantive. So let's start with procedure. And this is a really important point. We need to guard against pushing a merits judgment into the Article 3 injury in fact inquiry. And we also need to make sure we're not just as a matter of fact, even though we wouldn't say we're doing this, but as a practical matter, demand fact pleading. So merits judgment means, well, are you going to win or lose? And see, it's real easy for the court to go, well, I think you're going to lose, so therefore you don't have standing. That's not the test. Judges are not supposed to look at, well, who do I think is going to win or lose? Instead, it is, have you made an allegation that you were harmed, and that harm came from the defendant, and there's the ability of the court to do something about it. Okay, so I'll give you sort of a crazy example. Could you file a lawsuit, what was it, the 2000 election with Bush and Gore, and say, I think the Broward County didn't count the ballots right. And so I want a judge to say that Al Gore should be president. Well, assume I met every other requirement. The judge would say, we can't do that. Like, we don't have time travel, okay? We can't go back and put him in the White House and take Bush out. So it has to be redressable. And so that's all that it requires is you allege the injury, that it was caused by the defendant, and that it's redressable. In other words, in our type of cases, you can get damages for it. And so the judge says, well, look at this Lexmark case. And let me get this highlighted here. Distinguish between an adequate allegation of injury in fact and the question of whether that asserted injury fell within the scope of the statute. It's possible to point to a real injury but still lose on the merits. In other words, I could say, this debt collector called me up and they cussed me out and they said I was going to be deported back to the country I came from, and said all my relatives were inbred. I mean, just whatever stuff. And so that's enough for standing. And that would be enough to win the case too, by the way. But let's say that I said the collector was insulting to me. It might be insulting enough that the doors of the courthouse open, but then the judge says, well, that doesn't really violate the FDCPA. Okay, the fact that they weren't nice to you. And so the judge here is saying, look, be careful, guys, because you're starting to merge these two things here. And then we also have fact pleading. So fact pleading is where you had to plead, like in simple terms, like every fact in the case. And we're not supposed to do that now. I will say this, in the 11th Circuit, where I practice, the judges are going towards that. We're saying, well, you haven't pled all the facts. And eventually, I think the U.S. Supreme Court is going to say to the 11th Circuit, hey, we understand you did this with the best of intentions. You want to make sure these are good lawsuits, but you're violating the rules here. And so we have Federal Rules Civil Procedure 8A2, and what we're talking about is notice pleading. So you plead enough to put the defendant on notice, but it doesn't mean, for example, need not include allegations about every element of a claim. Instead, it's just this plausibility standard. And these are two just really important cases on pleading. In other words, how detailed does your complaint have to be? And the judge notes, nothing in those cases changed the rule requiring facts and reasonable inferences from those facts to be taken in the pleader's favor. In other words, you're the plaintiff, you file the complaint, the lawsuit. We have to give you the benefit of the doubt in that. And so a person may plead she was injured by a statutory violation. If she fails to prove that injury in the end, the court should conclude she loses on the merits, not that she never had standing to begin with. And the judge is saying, look, this opinion, it doesn't go all the way there, but it's starting down that path, and that's a bad path. Now, from a substantive standpoint, The question is, can she show a violation harmed or present an appreciable risk of harm? And the judge says, look, I agree with the majority or the panel's decision that is a test. Where I believe the panel's on shakier ground is the application of that standard. So it says, well, let's look at 1692G. And you'll remember this if you've seen our video, or you can look it up. But this is the actual text here. So within 5 days of the initial communication, debt collector shall, it's not a suggestion, but a requirement, send the consumer a written notice containing the amount of the debt, the name of the creditor, and then a statement that unless you dispute the debt within 30 days, the debt collector will be assuming that this is valid. And then here's where we get to the interesting stuff. Consumer notifies debt collector in writing within that 30-day time period the debt or any portion thereof is disputed. Debt collector will obtain verification or copy of the judgment and then mail that to you. And if the original creditor is different than the current creditor, if you ask in writing, they'll tell you that. So in particular, we're concerned with subsections 4 and 5 about in writing. Failure to do so is anything but a picky procedural gaffe here. 1692GB specifies, makes a written request. The debt collector shall cease collection until the collector takes those steps. So that's a crucial part. If you remember, if you send in a proper validation verification request, they either have to do nothing or they have to stop collecting until they verify the debt, or they have to get rid of the debt. So it's pretty powerful rights. And the judge here is saying, look, this is really important. And it says, people might not understand why they need a written record. And so this is a good reminder. When they receive a letter, they're often encouraged to call a 1-800 number, but someone who responds to debt collection in that way will be put in a gotcha situation. No notification in writing equals greatly diminished protection under the Act. And so going back to this notice pleading is why the judge put this few paragraphs above. It's a fair inference that the consumer's complaint that the debt collector's omissions at a minimum put her in imminent risk of losing the many protections. The right to verification, the name and address of original creditor, right to cessation are far from bare procedural rights. They are protections that serve as the gateway to the substantive part of this Fair Debt Collection Practices Act. So let's see here. I'll just highlight this part. Standing is not limited to cases has already suffered the harm. It may be actual or imminent. Read in the proper light. In other words, not where you have to plead every fact, but instead that let's give you inferences from this. Let's give you the benefit of the doubt. It's enough to infer an imminent, concrete, and particular injury. So the panel in our court reasons that the mistake didn't put you in harm's way and your pleadings did not spell out the various types of harms that loomed. They didn't say that had you gotten that information, you would have used those procedures to assert your rights. And here's what the judge is saying, kind of throwing up their hands and saying, surely the whole purpose of this opinion is more than just to alert future plaintiffs that they should plead they would stand on their rights. Okay? In other words, is that the whole point of this case? That we're telling people, when you bring this exact lawsuit in the future, just make sure you say, and I would have considered using my rights. It says a simple amendment would solve that problem. So if we're trying to get to the substance here, it's like, well, let's just let the plaintiff amend her complaint and then let's get on to the merits. And then they say, the key to differentiating between a bare procedural right and a right ground and substantive interest lies in concrete interest. Sixth Circuit captured this nicely. In Macy, that's again the identical case. To determine whether a procedural violation manifests injury in fact, the court properly considers whether Congress conferred the procedural right in order to protect an individual's concrete interests. And I like how this judge puts it. Point is simple. What and whose interest is the procedural requirement designed to serve? And judge says, well, look, if it says that the notice had to be printed on three-hole punch paper, it might be fair to say that doesn't really affect your rights. Okay? If it's a mistaken zip code, but the letter reaches you anyway, there's no harm to you there. But some procedures exist in order to protect underlying substantive interests, not just administrative convenience. And so the Ninth Circuit, after the Supreme Court looked at it, they sent it back to the Ninth Circuit in the Spokio case. And so procedural violation can by itself manifest concrete injury where Congress conferred the procedural right to protect concrete interest, and it's a risk of real harm. All right, so here's one way to look at it is, by analogy, fundamental due process requires notice and opportunity to be heard, not for the fun of reading the notice and listening to one's own voice, but because those rights guard against mistakes when the government is poised to deprive someone of protected interests. But taken to an extreme, even the right to notice and opportunity might be thought to be bare procedural rights because neither one assures an outcome. Again, why this judge said, guys, we're going down the path toward you're really looking at the outcome, not do the doors of the courthouse open. So, given the fact that a person is not told that objections under 1692G, A4, and 5 must be in writing or else they're ineffective, there's a strong case to be made. This case falls on the concrete injury side of the line, not on the bare procedural side. So, unlike the mistaken zip code, likelihood of ongoing injury from forfeited rights, remember, that would be things in the future. So if you don't act in the proper way, sending a verification request in writing within those 30 days, then going forward, you lose some rights. Now, as a practical matter, we can get a lot of those back through other ways, but it sure is easier using 1692G. And so I think the court here is tying it to, I forget the name of it, but that Second Circuit case, the Truth in Lending case, that said, well, if you're not told you can dispute charges in the future, but you have to do that in writing, then that's going to affect you in the future. Same thing here. And judge says, may have substantive defenses, and this would be things like bona fide error, hey, it was just a mistake. And so I express no views on the ultimate merits of the case. I express no views on the appropriateness of class certification. But here's what the judge says. Whether the plaintiff has pleaded enough to pass the injury in fact bar for Article 3 standing is questions whether that's so straightforward. And the Sixth Circuit view is so misguided that we should not hear this case. Judge saying, no, I think we need to hear this, all of us. So, okay, so here's a footnote. And so going back to that $5,000, okay, that's interesting. Just turns out that way. Apparently their net worth was $500,000, which is really an interesting coincidence. But 1%, so that's why the $5,000. The attorney's fees are a big ticket item, reason why Madison quickly agreed to settle the case. All right, so let me see if there's anything else. This footnote 4, this from the opinion, creates a circuit split, been circulated, majority did not favor rehearing. Chief Judge Wood, joined by Rovner and Hamilton, filed a dissent, which is attached. That's what we just looked at. And let's see. So here's a 11th Circuit case. And this is interesting. So this is the Church case. It said, create a right to injury that's similar to the Havens Realty. And I might review this case just so it'll put all this in context. But remember, the person at Havens Realty, they were just testing to see if the landlord was violating the law. so too the consumer allegedly alleged an injury to her statutorily created right to information pursuant to the FDCPA. And the Seventh Circuit says church does not give us pause. So they say, well, first of all, it's an unpublished opinion. So it's not even the law within the 11th Circuit, which 11th Circuit uses a lot of unpublished opinions. And technically, the 7th Circuit's right. An unpublished opinion is not binding on the court. But I'll tell you this. It's very unusual for at least the 11th Circuit to just ignore unpublished opinions. And then they say the debt collector and church failed to make any of the disclosures. And we're just talking about A4 and A5. And they say, but to the extent that church does recognize bare procedural violation of any disclosure is concrete injury, it's at odds with our decisions. And they say it also misreads Haven's reality. And so in any event, this is, I want you to see this, that here we have these judges that are looking at basically the same thing, coming to radically different conclusions. And it's why if you're doing this sort of stuff on your own, you have to really make sure you research it. And for lawyers that are watching this video, again, just a reminder that there are very few things that are just cut and dry. And so you need to look at that. And that's part of what I've been harping on for years about bring these cases in state court, let them get removed to federal court. Or if they don't, then, hey, we're happy in state court. But this sort of stuff can come up. It could come up in the middle of trial where a judge says, actually, I don't think that you have standing. So even though we're in the middle of trial, I got to throw out your case. Okay, so that would be very unusual for a judge to do it. But I've had companies do this to us. Right before we go to trial, they make this argument. And we're looking around like, hey, we've been litigating this for 3 years in federal court. You're just now making this argument? So just keep in mind there's a lot of variation on opinions about what the law is, what it should be. And so you really have to sort of do your due diligence to figure out, well, what's the best path to take? So I know this has been a long video. I have no idea how long it's been, but I'm sure it's been pretty long. And so for those of you who are still with me, thanks for watching this. Feel free to put any comments below. If you want to reach out to me, it's alabamaconsumer.com. My name is John Watts, or my phone number is 205-879-2447. And I will catch you guys in the next video. Thanks a lot. Bye-bye.